So the district court judge position is supposed to have very finite authority in a very finite place. Federal district court judges are not supposed to overrule the president on lawful decisions.
I think we should have an agreement. I'm not going to tell the older millennial how to properly groom a beard. He obviously can do it way better than I can, but he has to stop trying to explain the law to people. Federal judges, they rule on federal law. They have a geographic jurisdiction, which is the area where they operate, but their subject matter jurisdiction includes federal laws and constitutional issues that have application throughout the country. And before I get all technical on you, let me remind you that this is not a rule that we just made up in the last month. Federal district court judges validly blocked President Biden's executive orders on a number of occasions. One of them is DEI-related executive orders, Title IX related orders, and the Keeping Families Together policies of the previous administration. But I don't remember the older millennial getting all indignant about that. When a presidential action is brought before a federal court, the judge decides whether that action complies with the law or not, and not just whether it applies to the people in the judge's district. And this is not a new concept. It's a concept that was established in 1803 in a very famous Supreme Court decision, Marbury v. Madison. And that nationwide authority of a federal judge applies also to things called injunctions, which block orders and can have nationwide repercussions. How come a federal district court judge can block the act of a president? Because their job is just that. It's oversight over the actions of the other two branches to make sure that they don't exceed their authority or break the law. And that's the key element, because one of the things that the older millennial said was
supposed to overrule the president on lawful decisions.
The key word here is lawful. The decisions of the president of the United States are untouchable by the other two branches as long as they're lawful. But it's up to this branch at any one of the three levels to decide whether that action is lawful or not. If the president of the United States doesn't like the district court judge's decision, there's a thing called the appeal. Any other process would violate the separations of powers and therefore be unconstitutional. So absolutely yes, federal district court judges have the authority and, if called upon, have a duty to review the constitutionality of presidential executive acts, and if they deem it necessary, they have the ability to issue an injunction and block it. And anybody who tells you otherwise probably needs to read a book.